Counsel, go ahead and announce yourself and your case. I don't have these cases, so.
Good morning, Your Honor. Philip Arroyo on behalf of Miss Reitz, Sierra Reitz.
21 MM 5910. Ma'am, you're here because a warrant was issued for your arrest for violating a condition of pretrial release. There's no bond authorized on that warrant.
Your Honor,
Yes, counsel.
May we address the court, Your Honor?
Go ahead.
Your Honor, we would respectfully ask the court to find lack of probable cause in this case. If you go over the police report, my client was never anywhere near the alleged victim. She was going to go with her mother to pick up her belongings. They called law enforcement to be escorted. Law enforcement told them over the phone, it's okay, you can go pick up your car. And it wasn't even my client, it was her mother who went to pick up the car. She never had contact with the alleged victim, and she gets picked up in Lake County. She's been in custody for over a week. They transported her over here. So we would request a finding of no probable cause, Your Honor.
Counsel, I don't have the affidavit for this warrant. It was signed by another judge.
Yes.
And that judge has already found probable cause.
Okay. Well, in that case, Your Honor, we would like to make it known for the record that we've consulted with the state in regard to this case, and their position is that there's no objection to a reasonable bond. And Judge Shoemaker had also contacted the judge in Lake County and expressed having no problem with a reasonable bond as well.
Do you have anything from Judge Shoemaker to that effect?
I have an email.
I'll just tell you, without the affidavit and the information that Judge Shoemaker had when he signed this warrant, I'm loath to change the bond on another judge's warrant. But if you have something from Judge Shoemaker
Yes.
to that effect, I'm happy to review that.
May I have one moment?
Yes, go ahead.
Thank you.
Of course. Does the state have the affidavit for this warrant?
I'm looking at it now, Your Honor.
Thank you.
May I approach, Your Honor?
Yes, please.
And my apologies for not having it.
It's okay. Upstairs. Oh, to Judge Nemeth. I know him. We were prosecutors together briefly. Yeah. Oh, I see. Do you care if I keep reading? I'm just going to read the whole correspondence. Okay. And has the state seen this? Okay.
This state has not. This state has not.
Oh, the state assigned to the case? Okay, well, we can show it to you, Counselor. It's emails from the judges.
Okay.
All right, thank you. I'll just give you a minute to show her. So given that correspondence, does the state have any objection to the court setting a bond?
No objection, Your Honor.
All right, Counsel, did you have a bond in mind to request?
Your Honor, we would request, if an ROR isn't possible, the most reasonable bond available. Her mother is of limited means, so we would request the lowest bond. He has been in custody for 7 days over this, Your Honor. I mean,
I show no criminal history. Is that what the state has? Other than the arrest for battery domestic violence?
that is correct, Your Honor. Yeah.
Yes, Your Honor. No history.
All right, given the correspondence from Judge Shoemaker's JA where she said the judge has no problem with a court-setting bond, I'll set your bond at $500. All of the original conditions still apply to you, which includes the no contact and the don't return. So you understand that?
Yes.
And your attorney can go over all of that with you, but it looks like there could have been some confusion here, and I'd hate to see you violated again and brought back. So make sure that you have a nice, long conversation with your attorney so you understand what all of those things are, okay? You have to answer out loud.
Yes.
All right, good luck. Thank you, Counselor.
Thank you.
That's one more. And Your Honor, I have one more,
Oh,
if it's possible.
where? Who?
Miss Fatima. Oh, yeah, she's in mental health. We would verbally waive her appearance and request a reasonable bond. Miss Oizir, she is the owner of a hair salon.
We have a witness present.
Yes.
Hold on, let me call the case. This is 21 CF 12205. She's charged with aggravated battery and battery domestic violence.
That is correct, Your Honor.
All right, have you entered a notice of appearance on her behalf, counsel?
We have this morning.
All right. All right, go ahead, counsel.
Yes, Miss Oizir would be staying at the address of 5621 Millennia Boulevard if the court decides to grant her a reasonable bond and release her today. I believe the person that will be speaking today, I'm not sure if it's the alleged victim, but she will be staying at that address, which is the address of her friend. Seems to be a toxic relationship. We're not going to get into that, but she needs to be released on a reasonable bond, Your Honor. She's a business owner and owns her own hair salon, and she could be losing business because of this. So we'd be asking for a reasonable bond, Your Honor.
All right. Sir, did you wish to testify this morning?
Yes.
Please raise your right hand to be sworn.
Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I swear.
Please state your name for the record and spell your last name.
Anwar Larousi, Larousi, Laroussi. Last name, first name is Anwar, Anouar.
All right, thank you, sir. I'm going to ask if the state has some questions for you.
Good morning, sir.
Good morning.
How do you know the defendant?
Her husband,
Okay. Has something like this happened before?
well, my wife, she's not a violent person. My wife have met a friend that she's put her into drugs and made her not her normal. My wife is a very loving person, but I asked the court if they can give her a bond because she is a business owner. I don't want her to ruin her life because I'm part of it too. It would hurt me too with the business. However, to do help my wife with the drug problem that she get into because she's a good person, good-hearted person, but that's what got her to act like that. Like she called on herself in a way, so.
Sir?
I'm a 6'4", I'm not afraid. I just want no contact, if it's possible from the court, while the case is open till she get the help that she needs and we go from there.
All right, thank you, sir. Do you have any other questions, Madam Prosecutor?
No, thank you.
How about the defense have any questions for
No
this
questions,
witness?
Your Honor.
All right. Thank you, sir. I appreciate you coming this morning.
Thank you.
You can stay right there while we finish. So there is probable cause. You said that she's in mental health right now? All right, counsel, are you waiving her appearance for this hearing?
Yes, we are, Your Honor.
All right, I don't recall if you did that, and I just want to make sure the record is clear. I show no prior convictions, a prior battery arrest, actually 2 of them. I see arrests, but I see no convictions. Is that what the state has as well?
Yes, Your Honor.
All right, counsel, are you aware that we have a mental health pretrial release program?
I do not, yeah.
So it's pretrial release, but with some additional components for mental health.
Okay?
I can order that your client be screened for that. It usually takes a couple of days to get them screened.
Okay.
Is that something that you're interested in?
Yeah, that is fine, Your Honor. Yes.
If I do that, I'll still require a monetary bond, but I'll reduce it significantly.
Okay?
But it also means I don't know how long she could sit here. I don't know how long
What
it'll
would the
take.
bond be today for release?
$5,000 on count one and $100 on count two.
Yeah, we would proceed with that bond, Your Honor.
All right. With special conditions, she can have no contact with the victim. She must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather her belongings. She can't possess a weapon, firearm, or ammunition. She can't possess or consume any controlled substance without a valid prescription or any illegal drugs of any kind. Are there any other conditions the state would request?
No, Your Honor.
All right. Good luck, sir. Yes, sir. Do you have a question?
Your Honor, just what's just because she's my wife, what's the term of the psych that you said you're ordering the pretrial psych?
I'm not ordering that. She might qualify, but I don't know if she would. She'd have to be evaluated for it.
Okay,
And if the mental health issues are precipitated by drug use, I don't know if she would qualify. But I'm not ordering that at this time.
Okay.
At the request of her counsel.
Okay.
So she just has monetary bond. But I did order her to have no contact with you.
Okay.
She can come back one time to the house to gather some belongings, but she has to do that through law enforcement.
that's good.
All right.
Thank you.
Thank you.
That should be all, Your Honor. May I be excused?
Yes, sir. Have a nice day. Oh, a nice weekend. Thank you, sir, for coming.
Good morning, Your Honor.
Morning, counselor. How are you today?
Good, good. Joseph on behalf of Sebastian Romali. Here's the situation.
Wait. What's he charged with?
Misdemeanor, domestic
Okay, I had to find his case.
stalking, actually.
Okay, this is 21 MM 5734.
Yes, Your Honor. My client was arrested in Hillsborough County. So what we did is we had a stipulated order put in for a bond of $2,500 and no hostile contact. The judge was going to sign it this morning in front of Judge Shoemaker. He was transported downtown to Orange County Court for that reason. So we have court here in like 20 minutes in downtown.
Oh,
So
is he downtown?
he's downtown. That's what I was just told.
Okay.
The alleged victim is here. There is a Zoom link for her to appear, so I don't think she needs to Zoom down there, but I'm in the same room as him, get down there
Okay,
to address bond at that point. I'll ask the judge to do the initial appearance there. That's
okay. I think that's reasonable.
okay.
Any objection from the state?
No objection.
Okay.
All right, ma'am, are you the alleged victim in this case?
Yes.
And you have the Zoom link to appear?
I think so, yeah.
Okay, because we're not going to do this hearing right now. The hearing is going to be downtown with the judge assigned to the case.
Okay.
So you need to appear by that link at the time that it tells you, all
Okay.
right?
All right. Thank you, Your Honor.
And I don't want to make you late for court, but I just want to say, go Gators. But that's bold. Like, what if I was a Seminole? I mean, I'm definitely not. But no action at this time. They're going to do the first appearance downtown. So good luck. I hope you get there.
Thank you, Your Honor.
We can actually tell them. Let me have my J tell them he's coming. Good morning, counselor. How are you?
Morning, Your Honor. Well, how are you?
Excellent.
I'm here on behalf of Kenoris White. I assume that they're bringing him up.
What's he charged with?
He is charged with 1 count of battery, domestic violence, strangulation, and 1 count of misdemeanor domestic battery.
Okay, you said White? I got it. Kenoris White? All right, this is 21 CF 12139. Sir, you're here because a warrant was issued for your arrest, charging you with battery by strangulation, domestic, and battery domestic violence. Another judge has already found probable cause in this case. Counsel, did you wish to be heard?
Yes, Your Honor. We would request that the court set bonds in both counts. Is he entitled to bond? And with regard to count 1, we've requested $2,500 bond, and then treat count 2 as a subsidiary. And just for the record, he is a lifelong resident of Orlando.
All right, good morning, ma'am. Did you wish to testify this morning?
Yes.
Please raise your right hand to be sworn.
Do you
Sir,
swear
you look at me. Sir, you look at me.
Do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Krista Robinson, Robinson.
I just want to make sure that it's clear, and counsel, I'm sure that you would have if you had known he would do this, or you will have a conversation with your client about making any gestures or faces at any witnesses in this courtroom. You will not do that. Do you understand?
Yes, ma'am. I just noticed that she was here, that's all.
Yeah, I saw you shaking your head at her. You will not do that again. Do you understand?
Yes, ma'am.
All right. Let me ask, does the state have any questions for this witness?
Good morning, ma'am. How do you know the defendant?
We was dating.
I'm sorry?
We was dating.
Has something like this happened before?
No.
Are you afraid of him?
Yes.
Would you like to have contact with him while this case is pending?
No.
I have no further questions, Your Honor.
All right, thank you. Counsel for the defense, any questions for this witness?
No, ma'am.
All right, thank you for coming. You can stay right there if you wish while we continue this hearing. All right, Madam Prosecutor, you heard the defense request for bond. What says the state?
No objection.
I show several prior convictions, but I only show one as violent. Is that what the state has as well?
One moment, Your Honor.
I show some arrests for violent crimes, but I don't show convictions.
Yes, Your Honor. Just the battery.
Okay, all right, thank you. So counsel, I'm sure you heard the last defendant who was in front of me. Typically for crimes such as count one, without some aggravating or mitigating circumstances, I tend to set bond around $5,000. I understand that you're requesting $2,500. If I were inclined to do that, I would likely also place your client on pretrial release. I see he qualifies for that. Is that something that you and your client have discussed?
No, Judge, but if the difference is between a $5,000 bond and no pretrial release and a $2,500 bond and pretrial release, then I would request the court is set the bond at $5,000.
All right. Do you need a minute to discuss that with him, or you're?
No, ma'am.
All right. All right, sir, your bond is $5,000 on count one. However, I will treat count two as a subsidiary, and your bond will only be $100 on that count. With special conditions, you can have no contact with the victim. Do you understand what no contact means?
Yes.
You can't possess a weapon, firearm, or ammunition. Ma'am, are you two currently living together?
Yes.
All right. So I'm going to order that you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings, but you can't coordinate that with the victim. Do you understand?
Yes. You understand, Judge.
Are you okay, sir?
She's falsely got me in.
I can't hear you.
Say I'm falsely in here.
Yes,
Oh, okay.
He understands.
All right. Was there any allegation of drugs or alcohol involved in this incident? I don't recall that.
This was a warrant, so
I'm sorry?
this was a warrant, Your Honor, so I didn't have a chance to look at the affidavit.
Oh, it's there. I'm going to order that you have to surrender the firearm within 24 hours of your release, any firearm that you possess. All right, are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. Thank you, ma'am. Good luck. Thank you,
No.
counselor. Have a nice weekend.
Yep.
Please tell me your name.
Timothy Lewis.
All right, you are here because a warrant was issued for your arrest out of Nassau County in 20 CT 974 for failing to appear on a charge of driving while license suspended. Your bond is $1,502, and you're not allowed to drive. If you're not able to post that bond, we'll notify them and they'll transport you. But if you are able to, you can bond out here. Good luck, sir. Please tell me your name. Oh, Korean interpreter? Hold on. Do we know we need that? We might need to pass this and come back to it.
You want to start with the resets, or you want to start with the domestics?
I'm sorry, what?
You want to start with the domestics then?
What? What are these other two? Stanley, Tylis, and Alexander. Are those move-ups?
Stanley?
Gutierrez and Tylis are resets, Your Honor.
Why?
Gutierrez, I'm not
Do
sure.
we need to pass it?
Tylis is a reset for PC on that one.
All right, we're going to pass the Korean interpreter. We'll try to get one on the line. Let's do,
Your Honor?
I'm sorry?
Can you hear me all right?
Yes.
Okay, good.
Sorry, I was talking when you were talking, so I couldn't.
I'm sorry. I just feel that my voice is awful today.
The masks make it really hard to hear. I know we have to wear them, but it's really hard.
Once the mask come off, I'm going to be yelling all the time.
Right. All right, sir, please tell me your name.
Stanley Tylis.
You're here in 21 CF 12159, charged with trafficking in a controlled substance with greater than 4 grams and possession of a controlled substance. Was the state able to get additional information?
No, Your Honor.
Was the PD already appointed? All right. Hold on one moment. What was the reason for the reset, Mr. Brands?
All I saw was a reset. I reread through the arrest affidavit. I believe it was due to the weight. I don't think they ever took the weight and put that fact into the arrest affidavit. Therefore, there wouldn't be enough probable cause to charge trafficking over 4 grams. That was my takeaway, at least.
All right, so 20 pills is not over 4 grams. Let me look at this. 135. 1C. All right, so what says the state?
Your Honor, there were 2 drugs listed in the affidavit. I believe you still have PC for possession of those controlled substances.
All right, if you look at the statute, 893.135 sub 1 sub C, any person who knowingly sells, purchases, manufactures, delivers, brings into the state, or is knowingly in actual or construction possession of 4 grams or more. But it doesn't have a number of pills, it has a weight. So how do I know that 22 pills weighs more than 4 grams?
I believe that was the challenge, Your Honor, because they didn't weigh it, that there's no PC to charge under the trafficking statute. I would just have you ROR him until the state get the evidence, weigh it in, and charge him accordingly.
I won't do that because there is absolutely evidence that he possessed the controlled substances.
Then I would just have you find PC for possession of controlled substances, Your Honor.
Yeah, I think that's what I'll do unless the state can give me a reason not to.
Not at this time, Your Honor.
All right, so at this time, I find that there is probable cause that he possessed oxycodone and hydrocodone. On each of those counts, his bond will be $1,000. Sir, you can't possess or consume any controlled substance without a valid prescription. Do you understand that?
Yes, ma'am.
Yes. The judge already ordered random urinalysis through pretrial release. It'll be starting 24 hours after your release. Any other conditions that were already
No.
ordered?
So you are giving him pretrial release and bond?
No,
Oh.
I'm ordering random drug screens through pretrial release.
Okay.
Well, Judge Bain already ordered that. All right.
And is the public defender appointed?
Yes, they were already appointed. It's both possession. Yes, it's the same charge. It's 2 different drugs. All right, good luck, sir. Do we have the Korean interpreter? Oh, all right, we do. This is Judge Gibson. Who do I have on the line?
This is Kelly.
Good morning, Kelly.
Good morning.
Do you have a last name and are you an interpreter?
Yes, ID number 201170. Last name is Lee, L-E-E.
All right, thank you. Has the interpreter been sworn?
Yes.
All right. We have you over the overhead speaker in the courtroom. All right, sir, please tell me your name.
안녕하세요.
My name is
네,
Please.
한국어 통역원입니다. 이름을 불러주세요.
지영파.
My name is Ji-young Park.
You're here in case 21 MM583, charged with battery, domestic violence, and criminal mischief.
예, 지금 이 케이스 21MM583인데요. 오늘 고객님께서 여기 오신 것은 가정폭행 위반입니다.
There is probable cause in this case.
예, 그래서 여기 지금 케이스에 그 probable cause가라는 게 있고요.
I'll appoint an attorney to represent you.
그래서 변호사를 선임해 드리겠습니다.
근데 제가 말씀드리기 전에 저한테 언어한테 한마디 하고 싶습니다.
I'd like to go ahead and make my statement, please, to you, Judge.
All right, let me explain what we're doing here today before you say anything else.
예, 그러면 오늘 여기서 무엇을 하는지 먼저 설명을 하고 나서 얘기해 주세요.
This hearing is only to establish probable cause and bond conditions.
예, 지금 이 청문회는 먼저 어떠한 일이 있었는가를 먼저 알아서 반드에 대한 것에 보석금에 대한 것을 얘기하는 청문회입니다.
Everything you say here today is being recorded and can be used against you later.
그래서 오늘 여기에 말씀하시는 것에 대해서는 다 지금 녹음이 되고 있고요. 나중에 고객님 여기에 대해서 그 반대로 쓸 수도 있음을 알려드립니다.
I've appointed an attorney to represent you.
그래서 제가 그 여기 지금 변호사를 도와드릴 변호사를 선임해 드렸고요.
I'm going to ask him now if he has anything he'd like to say to you before you make any statements.
그래서 말씀을 먼저 해 주시기 전에 여기 있는 분하고 얘기를 해 주시기를 바랍니다.
You have to use the interpreter. I mean, you can try, but if he doesn't understand you.
I'm going to see if he
Okay.
he understands.
All right.
Thank a moment to confer, Your Honor.
Yes. Okay. All right, Mr. Park, after speaking with your attorney, do you still wish to make a statement here today?
예, 그래서 박 선생님, 그 지금 변호사와 얘기하고 난 후에도 지금 뭐 말씀하실 게 있으십니까?
예, 많이 있습니다만은 제일 중요한 말씀을 드리고 싶습니다. 예.
Yes, there's a lot of things that I wanted to say, but I'm going to make a statement for a very important thing.
Okay, please raise your right hand to be sworn.
Do you swear or
예, 그럼 오른쪽 손을 들어주세요.
do you swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, true.
오늘 진술을 할 때 정확하게 똑바로 얘기해 주실 것을 선서 증언하시겠습니까?
Yes or no?
Yes.
All right, one more thing. You can put your hand down.
네, 손을 내리세요.
One more thing I'd like to make sure that you understand before you make a statement. I show that you're on probation right now for a felony.
Yes, ma'am. Yes,
예.
ma'am.
그래서 고객님은 지금 중범죄로 집행유예를 받고 있는 걸로 알고 있습니다.
So I want also to be sure that you understand everything you say here today can also be used against you to violate your probation. Do you understand that?
Yes or no?
그래서 오늘 말씀하시는 것 중에서는요, 고객님의 지금 프로베이션에 대해서 고객님을 좀 적으로 반대로 고객님에게 나쁘게 될 수도 있음을 알려드리겠습니다.
Yes or no? First of all, I'm telling the most important situation right now.
Wait, before you continue, get closer to the microphone.
Yes, ma'am.
Okay, go ahead.
First of all, most important thing is today I'm coming here. Anyways, I got my mother, and my mother is 87 years old. Korean? 예, 저희 어머니는 지금 어머니를 한 번 모시고 있는데 87살이시며 지금 알츠하이머병에 계시기 때문에 내가 어떤 죄를 받더라도 제 어머니를 갖다가 지금 제가 테이크케어를 하고 있습니다. 외아들로서. 그래서 음식이라든가 약이라든가 메디신이라든가 아니면 하스피럴 같은 것을 제가 테이크로 하고 있습니다. 언제 어떻게 될지 모르는 상황에서 제가 여기 와 있는 것도 아무도 모르고 있는데 그런 상황에서 제일 답답해서
Can you take a break and let the interpreter explain it to me, and then we'll let you speak again?
yes or no.
Thank you.
So I have an 87 years old mother who has Alzheimer dementia, and I am the only son, and I have been taking care of my mother, such as giving her medication, food, and taking her to hospital, and no one really knows that I am here. 그래서요?
예, 그래서 그것이 제일 중요합니다. 그리고 제가 이런 얘기 저런 얘기는 못 하겠습니다. 지금 여기 변호사가 하지 말라고 그래서. 근데 저는 너무나 억울한 상황이기 때문에 그런 것은 어떻게 될지는 모르겠습니다만은 어려운 상황이지만 그런 얘기하지 말라고 그래서 안 하는데 어쨌든 그런 것을 좀 저기 우리 판사님이 좀 생각해 좀 해주셨으면 하는 것이 제일 중요한 문제입니다. 지금. 예, 감사합니다.
So that is most important about my mother. And although I have many things to say, my attorney advised me not to. So please consider what I am in the situation, please.
Yes, sir, thank you. I will absolutely consider that. At this time, your bond is $500 on count 1 and only $100 on count 2.
예, 그거 잘 이해할게요. 그리고 고객님의 반드는 1 카운트는 500, 2 카운트는 100입니다. 여기에 그 보석금이요.
You can have no contact with the victim.
피해자하고는 연락을 하면 안 되고요.
You can't possess a weapon, firearm, or ammunition.
예, 그래서 여기에 대한 무슨 그 무기도 가지고 있으면 안 되고요.
Sir, where does your mother live?
예, 어머니가 어디서 사십니까?
예, downtown is what kind of booth? Old ladies in there, and my store beside that my mother's apartment.
Does she live with you and your wife?
No, not
No, okay,
no.
okay,
I'm going to all the time to visit my mother. Very
Okay.
close.
okay. So I will order, you must maintain a separate residence from your wife.
예, 그러면 부인하고 떨어져 있는 데서 살으셔야 되고요.
And allow a one-time return with law enforcement to gather your belongings.
그래서 법에 있는 사람과 함께 한 번 가셔서 고객님의 소지품을 가져갈 수 있고요.
아니 제 와이프가 밖으로 나간다든가 그러면 안 됩니까? 뭐 이렇게 이쪽에서 도와줘가지고 제 집으로 돼 있는데 제가 거기 모든 게 다 있어가지고 이렇게 비즈니스를 하는 가운데서 그렇게 하고 있는데 어떻게 제가 나가야 됩니까? 와이프가 온 지는 4개월 됐습니다. just 4개월 됐습니다. 4개월을 지금 사는 가운데서 이런 일이 벌어졌습니다. 근데 그러니까 제가 이런 것을 다 얘기를 할 수 없어요. 왜냐면 모든 것이 그린 카드를 지금 받고 나서부터 시작이 되는 겁니다. 그린 카드를 받고 나서. 그러니까 이 모든 게 계획이에요. 와이프하고 저하고 나이가 차이는 좀 있습니다만은 모든 게 계획인 것 같아요. 다 계획이에요. 그리고 말도 안 되는 것을 다 그걸 갖다 설명을 하더라고요. 내가 그래도 기가 막혀가지고 내가 말을 못하고 있는데 나 때리지 않았습니다. 자기가 내 손톱으로 나를 긁어가지고 내가 이렇게 푸시라는 가운데서 이렇게 됐지 절대 때리지 않았습니다. 어쨌든 그런 상황입니다. 말하지 말아서 안 하려고 그랬는데.
Right, sir, I need you to speak in shorter sentences so the translator can interpret for me.
Yes or no?
So is there any way that she could leave and I could stay? Because I have a lot of business stuff in there. And this situation happened since she received the green card. And it's been only 4 months that we have lived together. And there's a lot of age difference. And I didn't really want to go into this because attorney advised me not to, but I did not hit her. And she is the one there who scratched me with her fingernail.
I understand what you're saying, and I wish I could do that. Unfortunately, this court does not have jurisdiction over her.
예, 그렇게 해드렸으면 좋겠지만요. 저희는 거기에 권할권이 없습니다.
However, if she does leave the house, you can live there.
그렇지만 부인이 거기에서 떠나면 고객님은 들어갈 수 있습니다.
Do you understand?
그런데 어떻게 떠나게 할 수 있는 방법이 없습니다. 그리고 그 사람이 7월 달에 비행기표 티켓을 끊었어요. 나 몰래. 그리고 한국에 나가려고. 왜냐면 거기 전 남편하고 애들이 있으니까 그런 계획이 있었던 것 같아요. 그래가지고 그린카드가 안 나오니까 지금 9월 달, 12월 달로 옮겼어요. 지금 넉 달을. 그래서 12월 달에 나가는 걸로 돼 있습니다. 그것도 원웨이로. 근데 갈지 안 갈지는 모르죠. 예, 그런 상황입니다. 그리고 전부 다 이게 플랜입니다.
So this has been all planned because she already planned to leave without my knowledge in in July, to go back to her previous husband and the children, and because of the green card matters, that she had extended till December.
Okay. I understand. I still can't order her to leave.
예, 그건 이해가 가지만 제가 그렇게 할 권한이 없습니다.
So if she leaves the house on her own, you can go back to the house and live there.
예, 그래서 만약에 부인이 그 집에서 떠나면 고객님은 들어가실 수가 있습니다.
So I'm just ordering that you must maintain a separate residence. So as long as she lives at the house, you cannot. But if she leaves, you can move back in.
예, 그래서 제가 지금 여기 명령 내리는 것은 따로따로 사시는 겁니다. 그분이 거기 계실 때는 못 들어가지만 안 계실 때는 그분이 나가면 살 수는 있습니다.
그럼 제가 어디 가서 살아야 됩니까? 지금까지 그 집에서만 살아왔는데.
So where do I go? I only have lived there all this time.
So on that green piece of paper is a phone number to call to speak with your attorney's office. Call them and ask for ideas.
예, 제가 지금 여기 변호사 사무실 전화번호가 있으니까요. 변호사한테 물어보세요.
그리고 지금 아시다시피 코로나19 그런 문제 때문에 여러 가지 비즈니스가 아무것도 장사도 안 되는데 지금 돈을 세이브해야지만이 되는 가운데서 지금 이렇게 이런 일이 벌어지는 상황에서 제가 집까지 나가면은 제가 스테이할 데가 없고 그렇다고 어머님하고 같이 있을 수도 없는 상황인데 그러니까 이제 전화번호로 이제 알아보라는 것 같네요.
So yes, due to the Corona-19, the business has been down, and in this case that I needed to save the money, and I don't know where else to go. I can't really live with my mom. So what you're suggesting is to talk to attorney, right?
Yes.
네.
예, yes or no?
Yes.
All right.
I will.
Good luck, sir, and get in contact with your attorney right away. Okay?
예,
예,
yes or no?
변호사과 빨리 얘기하세요. 감사합니다. 안녕히 계세요.
All right. Have a nice day. Thank you. Thank you, Madam Interpreter. That's all we have for you today.
Thank you. We'd like to thank you for using our service. Have a wonderful day. Bye-bye.
You as well. Is this Creole? No. No? Okay, so,
Let me get the Creole, man.
wait, do we have Creole? Nope, we're not ready. Go ahead. Please tell me your name.
Talia Alexander.
21 CF 12177. You're here charged with aggravated assault with a weapon, domestic violence, and battery, domestic violence. There is probable cause in this case. I'll appoint an attorney to represent you. Did you wish to be heard on bond, Mr. Brantz?
Does otherwise qualify for PPR, Your Honor, as limited criminal history as well as 2014 failure to appear, which 7 years old. She may, I would assume she's going to show up for any future court proceedings.
All right, what says the state?
No objection.
I'm sorry, did you say no objection?
No objection.
Okay, thank you. All I heard was objection, and I thought, are you objecting or not? Just want to make sure it's clear. All right, ma'am, at this time, I'm going to place you on pretrial release and require that you post a monetary bond. However, I will reduce that amount significantly. Your bond on count 1 will be $500. Your bond on count 2 will be $100. While on pretrial release, and as a condition of those bonds, you can have no contact with the victim. Do you understand what no contact means?
Yes, I do, hon.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. Are there any other conditions the state would request? I don't see any allegations of drugs or alcohol in this one.
No, Your Honor.
All right, good luck, ma'am.
Your Honor, Richard Haldemar on the ballot is not the
21 CF 12201. Mr. Brandt, I'm going to appoint your office in this case.
We'll waive the appearance, Your Honor.
All right, thank you for doing that. There is probable cause here. Did you wish to be heard on bond?
Oh, yes, they otherwise do qualify for PTR, Your Honor.
With a really significant violent criminal history. Is that right? Rebecca? Really significant violent history. What says the state?
I would ask that if you do PTR, that you also require a monetary bond, Your Honor.
I'm going to do that. I'll place him on pretrial release and require that he post a monetary bond of $2,500, no victim contact, maintain separate residence, one return with law enforcement to gather belongings, no weapons, firearms, or ammunition. Any other conditions the state would request?
No, Your Honor.
Okay. Please tell me your name.
Michael Paramore.
All right, this is 21 CF 12198. You're here charged with burglary of an occupied conveyance, battery domestic violence, and assault domestic violence. I'm going to appoint an attorney to represent you. Mr. Brandt, did you wish to be heard?
Yes, Your Honor. As to count 1, I would have a probable cause challenge as to burglary of a conveyance. According to the arrest affidavit, Frazier, which I believe is the alleged victim, was asking Mr. Paramore to bring the child and secure the car seat because it wasn't secured to the vehicle properly. So I believe there was some allowance to enter the vehicle. I wouldn't have you find PC for a burglary.
I read that as well. What says the state? It's in the third full paragraph.
Yes, I was reading the lead up, Your Honor. Yes, Your Honor, it does say that he was putting the child in the car seat. And once the door was open, that is when he struck Ms. Frazier. So I would agree, Your Honor.
I'm going to pull up that statute really quickly. 810.02. Yeah, it says burglary means entering or remaining in a dwelling, a structure, or a conveyance with the intent to commit an offense therein, unless the premises are at the time open to the public or the defendant is licensed or invited to enter or remain. or after permission to remain therein has been withdrawn. I don't know that there's any evidence in this probable cause affidavit that the permission was withdrawn. I see permission was given.
He was given permission for a specific purpose, which was to put the child in the car seat, Your Honor. It was not to strike.
Right, and that should have been in the back seat, not the front passenger door, because a car seat shouldn't be in the front seat.
Correct, Your Honor.
Separating that from the other two counts, I believe he was licensed or invited to enter the vehicle.
Oh, Paramore then said, quote, "scary bitch," and reached back into the vehicle. Okay, hold on. Let's read these sentences again. Paramore then opened the front passenger door, reached over with a balled fist as if he was going to hit Frazier, and she moved away, arguably withdrawing consent. Paramore then said, quote, "scary bitch," and reached back into the vehicle and struck Frazier on the bottom left side of the face.
Again, Your Honor, I don't believe that invitation or license was revoked according to the facts of the arrest affidavit. You can't assume. If it's not-
Moving away from his fist isn't enough.
If there was a fact in here that said, then she then replied, "get out of the car," we wouldn't be having the discussion. But because I don't see facts like that, that's my argument.
Well, it also is arguably a burglary of a conveyance with a battery or an assault, which is a punishable by life offense, and they didn't arrest it as such. I'm going to take all this under advisement. Ma'am, do you wish to testify today?
Yes.
Please raise your right hand to be sworn.
Do you swear
You look at
or
me.
affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Asher Frazier, Frazier.
All right, thank you. I'm going to ask the prosecutor if she has some questions for you.
Good morning, ma'am. How do you know the defendant?
He's the father of my 4-month-old child.
Wait, I didn't hear that. Can you get closer to the microphone?
He's the father of my 4-month-old child.
Thank you.
Has something like this happened before?
He has shown like verbal abuse. He's assaulted my brother on May 11th, May 10th, 2021. We didn't press charges because I went into labor a couple hours after that. My brother had to get his ears sewn back together because he struck him with his gun. So he's shown that he can be violent. He's made multiple threats that he's going to kill me if I don't let him see his child. So he's shown that he can be a violent person when he gets angry. When he's not angry, he's a very, very calm, very reasonable person to be around. It's only when he's upset that he shows that he can be violent.
Were drugs or alcohol involved in this incident?
No.
Are you afraid of him?
Yes.
Would you like to have contact
No.
with him? I have no further questions, Your Honor.
All right, any questions from the defense? All right, thank you, ma'am. Is there anything else you wanted to tell the court?
No, that's it. I mean, well, when he first, it stated in the statement that when he first came outside and he first came out trying to come in the car and hit me, but the door was locked. So he never have permission to come in the car and hit me. He actually slapped his fist against the wall, against the window of my car because he was upset that he couldn't open the door and harm me. So I've never wanted him to come in the car. All I wanted him to do was open the back door and just put Austin inside the car, and that was it, because he's done that before. So I don't know why today things had to be different. Well, yesterday it had to be different.
All right, thank you. All right, give me one more moment. I need to read again. All right, so what I did, counsel, is I then read your client's statement to law enforcement. in which he confesses to several crimes. Including the assault, which probable cause may be tenuous, but I think there's probable cause for a burglary of a conveyance with assault or battery, which is a punishable by life offense. Does the state intend to charge it that way?
Not at this time, Your Honor.
All right, I do think there's probable cause here. I'm going to place you on pretrial release and require that you post a monetary bond. Your bond will be $5,000 on count 1, $500 on count 2, $500 on count 3. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. Do you two live together? You have to answer out loud.
No.
All right. You can't return to her residence for any reason. You can't be within 1,000 feet of her residence or place of employment. Do you understand that? Did I say no weapons? All right, good luck. Thank you, ma'am. Good luck. We have Creole.
What's the defendant's name?
Francois. Misdemeanor battery. There is a victim? Oh, it's not the defendant who needs it? Oh. This is Judge Gibson. Who do I have on the line?
This is Nadej from Language Line Solution. My ID is 366712. I will be your Haitian Creole interpreter today, Judge.
Good morning. Has the interpreter been sworn?
Yes, Judge.
All right. Ma'am, please tell me your name.
Redline Francois.
I need everyone to
Madame-
pause between questions and answers so we can have the interpreter interpret for everyone, okay?
Madame, est-ce qu'on peut poser pendant yo pose question pour interpréter à interpréter pour m'a interpréter pour aujourd'hui.
Please tell me your name.
Est-ce qu'on peut ba nou nom?
Redline Francois.
Edline Francois.
21MM 6367. You're here charged with battery domestic violence.
Yo charge yo avec ou là parce que yo charge yo avec domestic violence avec batterie.
I'm going to appoint an attorney to represent you.
Moi pas ba un avocat qui peut représenter ou.
There is probable cause.
Est-ce que gen une raison?
Good morning. Do you wish to testify today?
Yes.
Please raise your hand.
Your other hand.
Do you swear or affirm that the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Can the interpreter not hear?
Yes, okay. Est-ce que levez mes doigts tout? Est-ce qu'on fait serment pour dire vérité, toute vérité, que vérité?
Yes.
Oui, I mean yes.
Please state your name for the record and spell your last name.
Est-ce que ka ba nou nom pour record et play signature?
My name is Bibel Son Nozile. My last name is Norzelin.
Good morning, sir.
Wait, the interpreter didn't translate that. Can you not hear him?
Judge, this is the interpreter. When they respond in English, do you still want me to interpret?
I ask him if he needs the services of the interpreter.
Est-ce que vous avez besoin de pour interpréter pour?
Oui.
Yes.
All right. Madam Prosecutor, go ahead.
Good morning, sir.
Good morning.
Bonjour, monsieur.
Bonjour.
How do you know the defendant?
Comment on connaît défendant?
C'est madame moi.
That's my wife.
Has something like this happened before?
Non, c'est
Est-ce qu'on
première fois.
bagaille comme ça? Est-ce que on bagaille comme ça passé avant?
Non, c'est première fois.
No, this is the first time.
Were drugs or alcohol involved in this incident?
Est-ce que tu gen alcool qui était présent le incident t'est passé?
Non.
No.
Are you afraid of her?
Est-ce qu'on peut?
Non, pas du tout.
No, not at all.
While this case is pending, would you like to have contact with her?
Pendant que ça en attente, est-ce que tu as aimé gen contact ensemble avec elle?
Oui, moi je veux contact avec elle et puis moi je veux faire mes caisses là.
Yes, I wanna stay in contact with her, and I also want to close the case.
I have no further questions, Your Honor.
Did the interpreter hear that?
Again, I heard. I'm sorry. Could you please repeat?
I have no further questions, Your Honor.
Moi pas gen question encore.
Thank you. Any questions from the defense?
Est-ce que défendant gen question?
No, Your Honor.
No.
All right, thank you. Ma'am, at this time, I'm going to place you on pretrial release.
Kounya, madame, kounya, ma mette ou, ma plage ou, sous préjugement.
Okay.
I need to clarify one question. Sir, did you say you do want contact with her?
Moi, je voulais clarifier une question. Monsieur, est-ce que vous dites ou voulez rester en contact avec elle?
Oui.
Yes.
I'm going to allow peaceful contact.
Moi, je voulais m'a quitter nous faire un contact qui en paix.
Ma'am, do you understand what peaceful contact means?
Madame, est-ce que vous connaissez les dit contact en paix? Qui ça veut dire?
Oui.
Yes.
You can't possess a weapon, firearm, or ammunition.
Ou pas gagner aucun arme ou bien munition.
You can't possess or consume alcoholic beverages, and you'll be subject to random alcohol screens.
Pas qu'à utiliser alcool ou bien ou bien bon test pour voir si ou gain alcool dans sang.
Okay.
Okay.
Good luck, ma'am. Thank you, sir, for coming. Good luck.
Bonne chance, madame. Merci, monsieur, d'être côté venu. Bonne chance.
That's all we have for the interpreter this
Anything
morning.
else, Judge? Thank you, Judge. Thank you for using our services. Have a good day.
Thank you, you as well.
Thanks. Bye-bye.
Your Honor, Vincent James, Mental Health.
21 CF 12212. 21 CF 12209. I'm going to appoint your office, Mr. Brands.
We'll waive the appearance, Your Honor.
All right, thank you for doing that. I do find that there's probable cause. I'm going to have him screened for mental health pretrial release. And require a monetary bond. It'll be, hold on one second. In 12212, $500 on each count. And in 12209, $500. No contact with either victim, no weapons, firearms, or ammunition, maintain a separate residence, one-time return with law enforcement to gather belongings. That's all. What happened to DeVecchio Sailor?
It's him right now, sir.
Oh. Sir, is that your name? All right. You're here in 21 CF 12211, charged with tampering with a witness to hinder communication to law enforcement and battery domestic violence. I'm going to appoint an attorney to represent you. There is probable cause here. Why doesn't he qualify for pretrial release?
Sailor?
Yes.
He did.
Oh, it says no.
There was a update.
Oh, I don't have it. Okay.
May I approach, Your Honor?
Yes, please. Thank you. Do you want it back, counselor?
No, I'm fine.
Okay. All right, sir, I'm going to place you on pretrial release and require that you post a monetary bond. On count 2, it'll be $100. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. Any other conditions the state would request?
Your Honor, I didn't hear the bond amount on count 1.
I didn't give one on count 1. It's just straight pretrial release on count 1, $100 on count 2.
Okay.
Good luck, sir. What? Yes, both PTR. Yes. Please tell me your name. 21MM6364. You're here charged with battery domestic violence. There is probable cause. I'll appoint an attorney. Hold on. I'm going to appoint an attorney first and ask him if he wishes to be heard.
Yes, Your Honor. As to probable cause for battery, I think the first paragraph in the arrest affidavit talks about hands were swinging. They were open and flat as if trying to slap Brown. And then towards the end of the affidavit, Brown was interviewed, saying she was not hurt. They were only arguing. So I don't know if there was any facts in the affidavit that suggested some contact. So I would just have you find PC for assault.
Just one moment. What says the state?
One moment, Your Honor.
I can't. Oh, one moment.
moment, Your Honor.
Sorry, with the sound, I just couldn't hear you. I can't hear anything.
I'll see you on September 23rd. Take care. Frozen on my screen. And can you guys hear me though? Can you hear me now? I can hear you now, Dawn. Okay. So, Mr. Pittsburgh, dear, I believe we said he was medical. This is case number 2018 CF 6318. We could reset him Friday, September 17th. Sorry. September 17th at 10 a.m.
Your Honor, my reading of it, the officer says, despite me seeing her attempting to hit Brown, is what the officer says, Your Honor.
Is attempt part of the battery statute?
No, it would be an assault, Your Honor.
It's a separate crime, right?
All right, we've got Eric Morgan, 2008 CF 10128. Lease that
All right, Mr. Brantz. I agree with you. I'm going to find probable cause for assault, not battery. Your bond will be $500. You can have no contact with the victim. Do you understand what no contact means? You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess or consume any alcoholic beverages or any controlled substance without a valid prescription. Good luck. What's the statute number for assault?
It's 784.011-4.
Thank you. That's right. No 4. 784.011.
So just assault, no DV?
Oh. No, you're right, it is DV. Thank you.
Your Honor, Jeremy Blair, mental health.
21 MM 6368. Mr. Brantz, I'm going to appoint your office.
Wait, the appearance, Your Honor?
There is probable cause. I'm going to have him screened for mental health pretrial release. Bond is $500 with mental health pretrial release, and if he doesn't qualify, it's just $500. No victim contact, no weapons, firearms, or ammunition. Maintain a separate residence, one-time return with law enforcement. All right, that's it. Please tell me your name.
Michael Coleman.
21 MM 6028. You're here charged with battery, domestic violence. A warrant was issued for your arrest, and another judge has already found probable cause for this charge. I'm going to appoint an attorney to represent you. Your bond is $500. You can have no contact with a victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. Good luck. Oh, and you can't, wait, come back. Well, I did a maintain separate because they reside there together. So I'm going to change that. All right, good luck.
Thank you.
Please tell me your name.
My name is Chris Evelyn.
21 MM 6374. You're here charged with battery, domestic violence. There is probable cause. I'll appoint an attorney to represent you.
She want me.
I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, I do.
You can't possess a weapon, firearm, or ammunition.
Understood.
As part of your, are you currently employed as a firefighter?
Yes, ma'am.
At your work, do you possess things like axes? You have to answer out loud.
Yes, ma'am.
Your Honor, I believe there's been a condition before where the defendant was allowed, I don't know if you remember this case or it was just for work purposes only.
Yeah, I'm going to order that in this case. So I think you have a dangerous job that's also very important, and I don't want to hamstring your ability to do that work while you're there. So if you're possessing something like an axe or, I don't know, any of those tools that you have to use at work for the purposes of work, you can do that. Don't bring them home. You understand?
Yes, ma'am.
You can only possess it for purposes of work. You must maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You can have no unsupervised contact with any minor child under the age of 18. All right, good luck. Please tell me your name.
Tommy Lee Jackson Jr.
21MM409, you're here charged with battery. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition.
Yes, ma'am.
Were you two living together?
No, ma'am. I stay with my mom.
All right.
560 South Hawthorne Avenue, Papa, Florida. 32703.
All right, thank you. So I'm going to order that you can't return to her residence for any reason, okay?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Fabio Satoshi, Kaim Kawanami.
21MM6371, you're here charged with battery domestic violence. I'm going to appoint an attorney to represent you.
Yes, please.
There is probable cause. I'm going to place you on pretrial release. And require that you post a monetary bond of $100. You can have no contact with the victim. Do you understand what no contact means?
I understand.
You can't possess a weapon, firearm, or ammunition.
Okay.
You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings.
Okay.
Good luck. Please tell me your name.
Joel Bernard Kennett.
21MM6349, you're here charged with battery domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause. You look at me, okay?
Who's talking?
Oh, it's me.
Okay.
I know, with the mask, it's really hard. But I just want to make sure because I'm going to address a witness and I want you looking at me, not the witness.
All right.
Good morning, ma'am. Do you wish to testify?
Yes.
Please raise your right hand.
Do you swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
Yes.
Please state your name for the record and spell your last name.
Cardell Dixon, Dixon.
Thank you. I'm going to ask the prosecutor if she has some questions for you.
Good morning, ma'am. How do you know the defendant?
My husband.
Has something like this happened before?
Yes.
With drugs or alcohol involved?
Yes.
Are you afraid of him?
Yes, very.
Would you like to have contact with him?
No, and he tell me that he's going to burn the house down with me, and they find my body as charred in the building when they burn it down.
I have no further questions, Your Honor.
Thank you. Any from the defense?
No questions, Your Honor.
All right, thank you, ma'am. Is there anything else you want to tell me?
I just don't want no contact. I'm afraid. I'm very scared. I am very scared.
All right, thank you. I appreciate that. All right, sir, at this time, your bond is going to be $500 with special conditions. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't call her on the phone. You can't send a text message. You can't go to her house, you can't send a message through friends or family, none of that. You understand? You can't possess a weapon, firearm, or ammunition. Yes, sir, did you have a question? You look at me.
Yes. I don't know if this is the proper time, but I'm listening to you. But can I give you some of my insight?
You can say anything you want. Everything you say is being recorded and can be used against you. I'm going to give you a moment to speak with your attorney.
Heat of action that's been taken, and it's been dropped before, and this is just circumstantial. It's none of this is it's truth. It's a history of doing this just to get me arrested.
All right. I don't know what the state's going to do with the charges, but the only thing we're here today for is probable cause and bond. So you'll want to stay in touch with your attorney. Sir, I'm going to order that you must maintain a separate residence. I will allow you to return one time to the home only with law enforcement. What that means is you coordinate with law enforcement to go back and get your toothbrush and your clothes, but you can't go back without law enforcement. If you do, you can be arrested and brought back to jail. Do you understand that?
Yes, ma'am.
And then after you go back that one time, you can't go back for any reason. You understand?
Yes.
You can't be within 1,000 feet of the victim's residence or place of employment after the one-time return. You can't possess or consume any alcoholic beverages. You'll be subject to random alcohol screens. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck. Thank you, ma'am.
You're welcome.
Good luck. Please tell me your name. 21MM6369. You're here charged with battery, dating, violence. I'm going to appoint an attorney to represent you.
Your Honor, he qualifies for trial.
Thank you. There is probable cause in this case. I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. Do you understand what no contact means? You have to answer out loud.
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. Were you living with her? You have to answer out loud. All right. So I'm going to order that you can't return to her residence for any reason. Good luck.
What was the bond amount, Your Honor? I'm sorry.
I placed him on pretrial release.
Your Honor, can we skip Ms. Osborne? They're going downstairs. She's coming up now.
All right.
Alonzo Pender is mental health.
21MM6378. Mr. Brandt, I'll appoint your office.
We'll waive the appearance, Your Honor.
All right, there is probable cause. Bond is $500. No contact with the victim. No weapons, firearms, or ammunition. Must maintain a separate residence. I'll allow a one-time return with law enforcement to gather belongings. That's it. Please tell me your name.
Jeff here. Good morning, Ms.
Good morning. 21MM6377, you're here charged with battery, dating, violence. I'm going to appoint an attorney to represent you in this case. Thank you. There is probable cause here. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. I'll order you must maintain a separate residence, and I'll allow a one-time return with law enforcement to gather your belongings. At this time, I'm revoking your bond in 21 CF 9617. I'm sorry, go ahead, Mr. Brandt.
I was just going to make it as the out on bond case, the the current charge isn't drug-related, so I would just have you revoke and double.
I'm not going to do that. It's not drug-related, but it's pretty violent, and I don't know that there weren't drugs involved.
Can I say something?
Yes, you can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Yes, ma'am.
Let me give you a moment to confer with your attorney, and then you can say anything you want.
Thank you, Your Honor.
Oh, all right. I assume that means he does not want to speak to the court now.
Oh, no, I'm sorry.
All right.
I'm sorry, Your Honor, I should have said something.
That's okay. I want him to make the decision that's in his best interest. I just,
Kind of walked off stage.
right, I assume leaving is a sign. Please tell me your name.
Jennifer Ogborn.
21 6372. You're here charged with battery domestic violence. I'm going to appoint an attorney to represent you in this case. There is probable cause here. Good morning. Did you wish to testify?
Yes.
Please raise your right hand. Look at me, ma'am, not you.
The testimony about to give, share with the truth, the whole truth, and nothing but the truth.
Yes.
Please state your name for the record and spell your last name.
Matthew Eldred, Eldred.
All right, ma'am, I need you to look at me or look over here at this wall, okay? Whatever's easiest.
Okay.
All right, I'm going to ask if the prosecutor has some questions for you.
Good morning, sir.
Good morning.
How do you know the defendant?
She's my girlfriend.
Has something like this happened before?
No. She's not a violent person at all. This is out of the ordinary.
Were drugs or alcohol involved in this
No.
incident? Are you afraid of her?
No.
While this case is pending, would you like to have contact with her?
Yes, I'd like to.
If something like this were to happen again, would you be okay calling the police?
Absolutely. I mean,
No
if
further
it's
questions,
something
Your
else.
Honor.
Anything, Mr. Brands, from the defense? All right. Thank you, sir. Is there anything else you wish to tell me?
Yeah, I wanted to just add to it. It was reason, I don't know if it was probable cause, but we've been struggling to get her Medicaid transferred over from Indiana to here. So she needs maintenance medications, and I think that's why the officers were agitated, and that's why they took her, because I didn't want to leave a statement or anything like that. That is definitely not how she is. She's not that type of person. So this is a really kind of a big misunderstanding, kind of.
All right, based on the testimony here today and the fact that I see she has no criminal history, is that what the state shows as well?
She is from out of state, Your Honor, but no, I don't show anything.
As far as income, I believe it's been 20 years on disability. If it's it, with victim testimony today, I would have you consider ROR. If not, if it qualifies for straight PCR with the ability to Indiana.
She lives in Orange County. I think if it was like a no contact order, she would go to Indiana. But she lives here.
Needs to go back for medical legal.
Right. I'm going to place her on pretrial release. Ma'am, you can look at me now. I'm going to place you on pretrial release, and I'm going to allow you to have contact. I'm just ordering that it has to be peaceful contact. Do you understand what that means?
Yes. Yes, ma'am.
No hostile contact, no hitting, no yelling. Just don't even raise your voice, okay?
Yes, ma'am.
All right, you can't possess a weapon, firearm, or ammunition.
No. What'd she say? Oh, okay.
No weapons. You can't have a gun.
Okay.
That's Any other conditions the state would request?
No, Your Honor.
All right. Good luck, ma'am. Good luck, sir.
Thank you, guys.
Please tell me your name. 21MM6370. You're here charged with battery, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Does the state have an objection to pretrial release?
No, Your Honor. No.
I'm going to place you on pretrial release with special conditions. You can have no contact with the victim. You can't possess a weapon, firearm, or ammunition. You must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. And that's all. Good luck. Please tell me your name. 21MM6348. You're here charged with battery, domestic violence. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can have no contact with the victim. Do you understand what no contact means?
Yes, but ma'am, we live in the same residence.
You can't now. I'm ordering you must maintain a separate residence. I'll allow a one-time return with law enforcement to gather your belongings. You can't possess a weapon, firearm, or ammunition. At this time, I'm revoking your bond in 21 CT 1513. Good luck, ma'am.
Your Honor, Jesse Banks is mental health.
All right. I think it's 21 CF 1934. Mr. Brands, I am going to appoint your office.
Wait, the appearance, Your Honor?
All right, it's a warrant out of Seminole. Bond is $30,000.
Yasaris Lopez bonded.
Okay.
Yasaris Lopez, they bonded.
Okay.
Nathan Palmer also bonded.
I don't have that one. I have Vincent Roundtree.
Mr. Roundtree.
All right. Sir, is that your name? Yes, ma'am. Thank you. You're here because a warrant was issued for your arrest out of Volusia County in 2020-306512 for violating probation on a charge of petty theft. Your bond is $1,000. We'll notify them that you're here, but if you can post the bond, if you're able to, then you can get out from here. All right, good luck. Please tell me your name.
Christopher Carruthers.
All right, it looks like you have a capias in 21 CF 7434 for aggravated assault with a deadly weapon, criminal mischief with damage greater than $1,000. I'm going to appoint an attorney to represent you. Your bond on count one will be $15,000. Count two is $1,000. You can have no contact with the victim, any co-defendant, or any witness in the case. You must maintain a separate residence. You can't possess a weapon of any kind, firearm, or ammunition. What about the capias in 21 CF 8369?
It was no cross.
It was null prost? All right. Then you have another warrant in 20 MM 6167 for violating your probation by leaving your county of residence, by committing the offense of operating a motor vehicle while your driver's license is revoked, resisting without violence, leaving the scene of a crash, and careless driving. At this time, your bond is $2,500. I'll appoint an attorney to represent you in that case as well. It's a misdemeanor VOP, counselor. Do you want to enter a denial?
We'll enter denial, Your Honor, yes.
Division A2, VOP status is October 5th at 1:30 in courtroom 10B.
All right, good luck, sir.
What was the date again? I'm sorry.
October 5th.
Please tell me your name. You're here because a warrant was issued for your arrest for violating your probation in 16 CF 12625 by failing to pay the state of Florida the amount of $20 per month and leaving your county of residence, committing the criminal offense of driving without a driver's license, failing to pay restitution, and the clerk of court. At this time, there's no bond authorized on that warrant, and I'll appoint an attorney to represent you. Good luck.
Your Honor, Benjamin Contreras is mental health.
20 CF 7068. I'm going to appoint your office, Mr. Brands.
We'll waive the appearance, Your Honor.
It's a probation violation with no bond. He might be a violent felony offender of special concern. Please tell me your name.
My name is Vladislav Dunayev.
Okay, hold on. You have a private attorney. I don't know if she's appearing. Let me see if we have anyone on the line.
Welcome to an Econo meeting. You are entering the meeting now.
This is Judge Gibson. Is there anyone on the line? All right, I don't hear anyone, but sir, I have.
I'm here. I apologize, Your Honor. I'm here. I just had muted the phone. I apologize.
That's all right. Technology has been our saving grace, but it's also difficult at times, so I get it. And Counselor, I'm pretty sure I know your voice, but go ahead and put your appearance on the record, please.
Rhiannon Arnold Rogers on behalf of Mr. Denevave.
All right, this is 20 CF 8074. Sir, a warrant was issued for your arrest for violating your probation by accessing the internet, it looks like on 2 occasions. There's no bond authorized on that. Counsel, did you wish to be heard on anything?
Your Honor, he was picked up in Lake County, which is his county of residence. It looks like the probation officer has made a recommendation. He had not been on probation very long, and I understand, Judge Gibson, that you're not the judge of record. I don't know if it was signed as a violation that could be modified at IAs. We're going to request, if it can be modified, that a reasonable bond be set in this matter. But I understand if it's not a bond if it's not a warrant that was set in such a way, if it can't be modified, or a bond set in the matter, we understand, and we'll just have it set in front of Judge Strobridge.
Yes, thank you, Counselor. I appreciate that. I think you do need to have it set in front of Judge Strobridge. She and I have communicated not about this case, but prior violations of probation, and I do not modify her warrants.
I understand, Judge Gibson. I appreciate that greatly. We'll go ahead and get a motion set and present it in front of her. Thank you very much.
Absolutely. All right, sir, at this time, you'll have no bond, but you heard your attorney. She's going to try to get you in front of the trial judge as soon as possible. You understand? He's nodding yes.
Yes.
Okay, good luck, sir.
Yes,
Thank you,
Judge.
Counselor.
Thank you. Thank you, Judge Gibson. Have a wonderful weekend.
All right, you as well. Please tell me your name.
Joshua Garland.
20 CF 4724. A warrant was issued for your arrest for violating your probation by failing to successfully complete or remain in drug or alcohol treatment. There's no bond authorized, and I'll appoint an attorney to represent you. Good luck.
Connor Lewis Jones is mental health.
All right, this is 21 CF 12202, 21 CT 6224 and 25, 21 CF 12199, 19 CF 15710, 21 CF 12207. Why there are 5 probable cause affidavits for one incident baffles the court. However, there are. Mr. Brands, I'm going to appoint your office in all of these cases, including the violation of probation.
John, did you have 3 traffic cases? I think I only heard 2.
I only have 2. Hold on. '21 CT 6223. Yes. That's the leaving the scene. I said that. Oh, it doesn't have the citation. I got it. Mr. Brands?
We'll waive your turn, Your Honor.
All right, there is probable cause. I'll stay the bonds at $500 on 6223, it'll be $500. It'll be $1,000 each on the other 2 CT, 6224 and 225. And then 21 CF 12202, it'll be $15,000. 21 CF 12199, it'll be $5,000 on count 1, $100 on 2 and 3. And there's no bond on the violation of probation. On all of the new law violations, the same, well, no. It's going to be different, I'm sorry. 12199. That's the grand theft. Grand theft will have no victim contact, not return to the scene. All of the other offenses are the same bond conditions. Cannot drive without a valid Florida license. Oh, 07? That's 15,000. No, 07, 12207. I don't know where that one is. Oh, that'll also be 15,000. No contact with any co-defendant or witness in the cases. That's all. Please tell me your name.
Brandon Thomas.
20MM331, you're here for a violation of probation. A warrant was issued for your arrest for committing the offense of false name or identification to law enforcement, possession of cocaine, and possession of drug paraphernalia, that you didn't comply with instructions given, failed to pay, failed to attend and complete the cognitive behavioral change program, and failed to complete 50 hours of community service. At this time, there's no bond. I'll appoint an attorney to represent you. Good luck. All right. Go ahead and bring him in, though. We'll find it. Okay. Thank you. Please tell me your name.
Tyler Robert Scott.
A capias was issued for your arrest in 21 MM 5343 for failing to appear for arraignment on a charge of trespass in a structure. The bond authorized is $1,500. Was there an offer in this case?
Adjudication of guilt, credit time served, no return to 2791 Bent Willow Circle, Apartment A. There's also a cost of investigation of $144.10 to OPD.
I don't know that I'll accept that in this case. When was this conviction for?
Your Honor,
lewd or lascivious, and aggravated child abuse.
June of this year, Your Honor.
So I'm not going to accept a plea on this case without additional information.
Mr. Scott's also on probation, Your Honor, so we wouldn't be interested in a plea offer at this time.
Okay,
Just the
all right, I
bond is
understand.
sufficient. Thank you.
I'm going to appoint an attorney to represent you, sir, and you have that bond. Good luck.
You'll get one aside.
We still don't know her name? Okay. All right, thank you. Ma'am, please tell me your name.
Brittany. Fritz.
Thank you. You're here in 21 MM 6350, charged with resisting a merchant, providing false identification to a law enforcement officer, and retail petty theft. I'm going to appoint an attorney to represent you. There is probable cause here. I'll stay your bond at $500 on count 1, $100 each on counts 2 and 3. You can't return to Circle K at 2704 South Fern Creek Avenue. Do you understand?
Is this Florida?
Yes.
Oh, interesting.
So you know that you can't go back to that Circle K.
Actually, why is that? They have filthy bathrooms. They also have very filthy staff. I ate a donut there from there the other day, so therefore they actually owe me money for putting my health into jeopardy. Also, I was arrested without my full rights being read to me. I've had injuries sustained since I've been here. I've been given dirty food. My cell is filthy. Have you guys taken the time to Google me? Where are my items? Where are my things? I should be released instantly, actually.
So, no ma'am, I don't Google any of the defendants who appear in front of me. What I do is I review the probable cause affidavit that was written by, hold on, let me explain to you what we're doing here. That was written by the arresting officer, which includes any statements by witnesses and sometimes by the person who was arrested if they make statements. I review that information and then I make a determination if there is probable cause and what bond conditions will be. That's the only thing we're doing here today. So it sounds like what you think is you have some defenses to this. You also brought up some civil issues, but you're going to have to talk to a civil attorney about those things.
Okay. How do I press charges against the Circle K?
So I can't give you legal advice. You have to talk to an attorney about that.
I would love paperwork for such things. Oh, okay. Perfect. Thank you.
All right, so you can't go back to that Circle K. You can't have contact with any of the witnesses in this case. And that's all. Good luck, ma'am.
She's probably not wrong. That's okay.
Good afternoon, sir. Could you please tell me your name?
Barry Joseph Barry Jr., Joe Barry Jr.
All right, thank you, sir. You're here in 21 CF 12215. You have 2 counts of violating sex offender reporting requirements. At this time, I'm going to appoint an attorney to represent you.
Your Honor,
Yes, go ahead, Mr. Brandt.
as to his out on bond case.
Wait, hold on. Did you have a probable cause challenge?
No probable cause.
Okay.
I'll wait till you get there.
I agree. I think there is probable cause. Let me just deal with this, and then we'll go to the out on bond. Because there's probable cause, I'm going to set bond. I'll stay it at 1,000 on count 1, 150 on count 2. Sir, you understand that if you bond out, you have to maintain your sex offender reporting requirements?
Yes, ma'am.
Okay, and as to his out on bond, yes, Mr. Brandt?
He has been deemed incompetent in 2018 CF 3750. I have the order from the court on my computer. Would that have any bearing on your setting of bond in the current charge, perhaps release ROR?
No.
With the condition to report?
No.
It won't, and I'm sure counsel recalls that I would typically set this bond at $15,000, but I did not today. because it came in as 1,000. I left it.
Would you like to see the conditions of release in this other case?
Yes, please. Has the state seen it?
No.
I'll bring it.
Okay. Yes, please. All right, Mr. Barry, thank you for your patience. Give me one more minute, okay? I need to look at some things. All right, Mr. Barry, I'm almost done. Sorry, I needed to read some things, so thank you for your patience. All right, here's what I'm going to do, Mr. Barry. Based on the arguments of the attorneys, on count 1, your bond will be $5,000. On count 2, it'll be $150,000. Now, I understand after I read this that someone from the sheriff's office explained to you that you have to register as a sex offender. Do you understand that? So you understand that if you post this bond, you have to maintain those requirements?
Yes, I do.
All right. You're not allowed to have contact with any minor children under the age of 18. Do you understand that?
Yes, I do.
Which means you can't walk any children to school.
I wasn't intending to.
All right. I'm going to take no action on his out on bond cases based on the order of the court in 18 CF 3477, finding the defendant incompetent in May of this year. But we'll see what happens. All right, good luck, sir. Stay in contact with your attorney. Please tell me your name. 21 CF 9335. A warrant was issued for your arrest, charging you with burglary of a dwelling, grand theft from a dwelling, and 5 counts of fraudulent use of a credit card. Another judge has already found probable cause in this case. Your bond is $5,000 on count 1, $1,000 on each subsequent count. You can have no contact with the victim or any witness in this case. You can't return to 1927 Americana Boulevard. Do you understand that?
Yes, sir. Yes, ma'am.
You can't possess a weapon, firearm, or ammunition.
Yes, ma'am.
Any other conditions the state would request?
No, Your Honor.
All right, good luck. Yes, sir, do you have a question?
They told me I had a 5-day hold, and I was instructed by pretrial and the officer to find out why was the hold, because I was supposed to have a bond, and I was trying to bond out yesterday, but they told me I had a 5-day hold.
Your Honor,
They said it can only be lifted through my initial appearance.
So it looks like you're on community control right now.
Community control officer asked me to come report to her as soon as I'm released.
So that's probably what the hold is.
So
What they do is if you're arrested on a warrant or for a new law violation and we know that you're on probation or community control, they'll hold you until we get something from probation or community control, because they usually will issue a warrant for your arrest for violating that. So if your community control officer is not going to issue that warrant, then they'll release that hold. But I can't do that right now because I don't know if a warrant is coming.
I spoke with my officer. I have her number. Y'all can talk to her live if I want to and ask her.
No, she'll issue something and then we'll know. if there's going to be a warrant or not. Yes, sir.
Anna Peter Cortofino, refused.
21 CF 12216. Mr. Brantz, I'm going to appoint your office.
We'll waive the appearance, Your Honor.
Does the state wish to be heard on bond?
Sorry, Your Honor, this is an add-on, and I know he's already been held, no bond.
I can't hear you. What?
I'm sorry. This is an add-on, and I know he's already being held, no bond.
What do you mean it's an add-on?
These are add-on charges.
I don't know about his other charges. I only know about these.
Yes, Your Honor.
Are the other charges life felonies?
Yes, Your Honor.
What level offense are 1 and 2 in this case?
I do not believe they are life felonies, Your Honor. I believe anybody's off.
How old is the child alleged? Is the child under 12?
Yes, Your Honor. I think he's either 8 or 10 years old.
All right, so the offense is a life felony, but attempt knocks it down to a first.
Yes.
All right, his bond is $1 million on count 1, $1 million on count 2. Count 3, 4, 5, and 6. His bond will be $50,000 each. Count 7 and 8. Will also be $50,000. He can have no contact with any victim or witness in this case. He can have no contact with any minor child under the age of 18. He can't possess a weapon, firearm, or ammunition. And that's it. Please tell me your name.
D'Angelo Austin.
21 MM 6365. Sir, you're here charged with trespass on property after warning. There is probable cause. Was there an offer in this case?
Yes, Your Honor. Adjudication of guilt, credit time served, no return to the Lexington Court Apartments at 315 West Concord Street.
I did have a chance to convey that offer to Mr. Alston as well as a plea form to review, and I believe Mr. Alston wishes to enter a plea of no contest today.
Please raise your right hand to be sworn.
Do you swear or affirm that testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. Are you interested in accepting the state's offer?
Yes, ma'am.
You can put your hand down. Did you have a chance to review the form that explains all the rights you'll be giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You were just here last month, it looks like. I don't know if I saw you. Did you see me or another judge?
I don't know. I'm pretty sure it was disorderly.
All right. You understand that if you enter a plea of guilty or no contest today, if you're on probation anywhere, this plea can violate that?
Yes, ma'am.
If you're not a U.S. citizen, you can be deported?
Yes, ma'am.
All right, sir, you have any questions for me about the rights you're giving up?
No, ma'am.
At this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in custody. I have to order that you pay court costs. I'll give you a year to pay that, and I'm going to order that you're not allowed to return to the Lexington Court Apartments. Do you understand that? All right, good luck, sir. You have 30 days to appeal in writing. What happened to Desiree George? Okay. Please tell me your name.
Joshua Leister.
All right, it looks like you're here for 2 cases. 21 MM 6375, you're here charged with resisting an officer without violence. I'm going to appoint an attorney to represent you. There is probable cause. Your bond is $500. You can have no contact with the co-defendant, Desiree George. In 2019 CF 3391, you're here for violating probation out of Lake County. At this time, you'll have no bond on that charge. We'll notify them that you're here so they can come and get you. And you have, looks like 2 out on bond cases, 20 CF 15015, 20 CF 2584. At this time, I'm revoking your bonds in both of those cases.
Consider no action, Your Honor, so he can return to Lake to deal with his probation violation.
No, I will not at this time. Good luck, sir.
Manuel Rodriguez refused.
Did you say Manuel Rodriguez? All right. 21 MM 6366, I'll find his refusal a willing waiver of his appearance today.
Your Honor,
I'm going to appoint Mr. Brantz. Yes, go ahead.
I believe there were some lacking facts in the affidavit. I believe the state may want to 24 hours.
Like all of them? All of the facts?
Most of them.
Right.
We're not there.
It's a very astute observation, Counselor. I do agree with you in that, in this instance. Does the state?
Yes, Your Honor, the state does request 24 hours in order to get the necessary facts.
All right, I'll give you 24 hours, Counselor.
Thank you.
Please tell me your name.
Miguel Sharman Bailey.
All right, this is 21 MO 1046. You're here charged with violating state misdemeanors. There's probable cause. Was there an offer?
This falls under the city, Your Honor, so I just do it as a withholding the credit time served office.
Your Honor, I did have a chance to convey that offer to Mr. Bailey and a plea form to review before court. I believe he wishes to resolve this case today.
All right, raise your right hand, sir.
Do you swear or affirm that testimony about to give the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. So did you have a chance to review that form explaining all the rights you're giving up if you enter a plea of guilty or no contest? Do you have any questions for me about those rights?
No, ma'am.
Do you understand them?
Yes, ma'am.
And you understand that if you're on probation anywhere, this plea could violate that?
Yes, ma'am.
And if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
Are you sure he's not on probation, Counselor? So I show that he has a conviction, 5/19/2021, for possession of synthetic cannabinoid.
Just a moment to confer, Your Honor.
Right, I just want to make sure he's not actually on probation.
I didn't see anything on my end, but I will ask real quick.
Does anyone know? Are we confident in that?
No.
What was that sentence? I mean, that was just May. Can you ask him if he recalls what that sentence was? And he doesn't have to say it on the record.
Yes, Your Honor.
That seems like a charge that could have probation. All I have is his name.
Yeah, Your Honor, I don't believe he's on probation. He's pretty confident he's not on probation in any case at the moment, including the one from May.
All right, even the one from May. The reason I'm asking is because if you are on probation anywhere and you enter a plea of guilty or no contest to this case, that could violate your probation. You could be arrested, and that, if it's a felony, a third-degree felony, I mean, you could be subject to 5 years in prison. I just want to make really, really sure. You pled in May of this year?
And I think that was in another county.
Okay, so it wasn't in our county?
It wasn't in our county.
No, that's it. Okay, good. Not probation. Thank you. All right, sir. I'm confident now that you're not on probation in that case, but I still don't know about all of your cases. So with that information in mind, do you still want to enter a plea of guilty or no contest today?
Yes, ma'am.
All right. At this time, how do you wish to plead to the charge of violating state misdemeanors?
Guilty.
I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the time that you've been in custody. I have to order that you not return to the Wawa at 1200 West Colonial Drive. You know where that is?
Yes, ma'am.
Okay, don't go back there. I have to order that you pay court costs. I'll give you a year to pay them. Good luck, sir. You have 30 days to appeal in writing. What? Please tell me your name. 21MO1047. You're here charged with violating state misdemeanors. There is probable cause. Was there an offer?
Withhold of adjudication and credit time served.
And I did convey that offer to Mr. Mavronis, Your Honor, as well as a plea form to review, and I believe he wishes to plead no contest today to resolve.
Please raise your right hand.
Do you swear or affirm that the testimony about to give should be the truth, the whole truth, and nothing but the truth?
I can't hear you. Did you say yes?
Yes, Your Honor.
All right, thank you. You can put your hand down. You had a chance to review that form that explains all the rights you're giving up. Do you have any questions for me about those rights?
No questions, Your Honor.
You understand them?
Yes, Your Honor.
You understand that if you're on probation, this plea can violate that.
Yes, Your Honor, ma'am.
If you're not a U.S. citizen, you can be deported.
Yes, Your Honor.
I see here that you were last convicted, looks like last week, for trespass on property after warning.
It's my wife got an injunction on me. I can't go home. I've been wandering around catching these ridiculous charges that normally wouldn't happen because my wife she got an injunction on me. I can't go home. I'm waiting until next month, get my next check, and probably go back to Daytona.
Okay. Well, good. I'm glad that you're not going back. If there's an injunction,
Yeah.
good, staying away from there.
That's fine. I'm not gonna leave here and go right back to jail again. It's just kind of messed up. I feel like I don't know which way's home, which is the only thing I know in Orlando right now.
All right. At this time, how do you wish to plead to violating state misdemeanors? You can plead guilty, no contest, or not guilty.
No contest.
All right, I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs, and I'll give you a year to pay them. Good luck, sir.
Time served?
I'm sorry?
I get time served?
Yes, sir.
Going back that way.
Please tell me your name.
Ricky Tyrone Neal Jr.
21MO1048. You're here charged with open container of an alcoholic beverage. There is probable cause. Was there an offer?
Withhold of adjudication and credit time served.
Why would the court withhold adjudication? He's,
Well, Your Honor, he's also on probation. I would just have you set bond.
all right. I'll do that at this time. So,
Would you consider ROR as a bond condition as we have all this information about the probation?
what says the state?
I would prefer bond, Your Honor.
I'll reduce it to $100. Sir, you can't possess or consume alcohol, and you can't go back to that Lynx bus stop. You understand that? You have to answer out loud.
Yes, ma'am.
All right, good luck, sir. If he's violating his probation, he'll be held.
Just a moment, Your Honor, to confer with Mr. Patrick. Thank you, Your Honor.
Please tell me your name.
Jonathan Patrick, ma'am.
21MO1049. You're here charged with disorderly conduct. There is probable cause. Is there an offer?
Withhold of adjudication and credit time served.
So why does the state keep asking the court to withhold adjudication when people have really lengthy criminal histories?
Only because it is a city ordinance, Your Honor, and my understanding is that is what the city has authorized the state to offer on these cases.
Can you go back to them and say the court wants to know why you keep asking the court to withhold adjudication on people with really lengthy criminal histories?
Yes, Your Honor.
Because the purpose of the withhold is so that they don't have a conviction. He's got 40.
I think it's also the nature of the charge, Your Honor. Very low-level charge.
All right, Mr. Patrick, did you hear the state's offer?
Yes, ma'am.
Are you interested in accepting that?
Yes, ma'am.
Please raise your right hand to be sworn.
Do you swear affirm the testimony about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Sir, did you have a chance to review the form that explains all the rights you're giving up?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
Do you understand them all?
Yes, ma'am.
You understand if you're on probation anywhere, this plea can violate that?
Yes, ma'am.
Hold on. Are we confident he's not on probation? You are? You're not? Okay, all right. The reason I'm asking that is this would be an automatic violation. So that's why I'm asking. Okay. And you understand if you're not a U.S. citizen, you can be deported?
Yes, ma'am.
All right. At this time, sir, how do you wish to plead to disorderly conduct?
No contest, ma'am.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days you've been in custody. I have to order that you pay court costs, and I'll give you a year to pay them.
Yes, ma'am.
Good luck, sir. You have 30 days to appeal in writing.
Ana Jose Batista Perez, bonded.
Okay.
And Ricardo Salas Perez, bonded also.
Please tell me your name.
Douglas James Addison.
A capias was issued for your arrest in 21 CF 1468 for grand theft. The bond is $1,000. You're not allowed to have any victim contact or return to the scene of the offense. And at this time, I'll appoint an attorney to represent you.
Ma'am?
Your Honor, I believe Mr. Addison would like to request the court set the bond condition as released on own recognizance.
I'm not inclined to do that. I'm looking at your client's history. Looks like he had his most recent convictions in 2020.
Well, we tried to get all that cleared up, ma'am, before we pled guilty out on that. And I don't even have no idea what this is about. And they had me for failure to appear on this. And I had never even been charged for it. I don't know how I could be in Osceola County. They said I had a failure to appear on it. And I just had major back surgery on my back. I had,
This isn't a failure to appear, sir.
there's no way I can be ROR'd. I've lost all my family in the last 3 years. I can't get out.
I'm not going to do that at this time because I'm looking at your record.
Yes, ma'am.
And like I said, your last offense, your last conviction was in 2020. It's also for a theft. But I've appointed an attorney to represent you. Get in touch with your attorney right away. They can file a motion in front of the trial judge who will have more information than I do, and that judge may change the bond.
I don't even know what this is about.
Unfortunately, I don't have that information because it's a capias. Let me ask, does the state have it?
One moment, Your Honor.
Let's see, if the state can put a factual basis on the record, sir, then you'll know what it is. Victim.
Your Honor,
Just a moment, she's looking for the factual basis. All I have is the capias.
I think I'm looking at the wrong thing.
Osceola said I had a failure to appear on this charge, and I've never been arrested for it.
No, this is the arrest.
Yes, ma'am, but how did it come up with a failure to appear down there?
I don't know, I don't see a failure to appear. Hold on.
Honestly, the paperwork said that.
I don't see that. It maybe someone was confused because it's a capias, but there's two kinds of capiases. This is a probable cause capias.
Yes, ma'am.
Your Honor, the affidavit that's attached to this 2021 case is from 2018. It's saying defendant did commit the offense of grand theft by knowingly attempting to obtain merchandise from Home Depot by carrying away said merchandise with the intent to permanently deprive them of that merchandise in the value of $756.
Did you say at Home Depot?
Yes, Your Honor.
Okay. So that's the factual basis. Now, listen, I'm not asking you to defend against that right now, but I just wanted you to hear what it is so you understand where the charges are coming from.
Yes, ma'am.
However,
I don't know why it didn't come up earlier when I went and did my time, because Judge Wooten in Kissimmee, he said, we're going to look and make sure he has no more charges. And that was like in 2019, and I went and did my time, and I thought everything was cleared up.
I see. It might have been a course of conduct. There were multiple arrests, but they didn't issue this capias until the 5th day of February 2021.
Why would they wait like that?
I don't know. So what'll happen is your attorney is going to have to talk to the state attorney's office because that's who's bringing the charges against you, and I don't have that information. However, based on what I just heard, I am going to reduce this bond. I can't release you on your own recognizance, but I'm going to reduce it to $500 with the same conditions.
So much, ma'am.
$500.
Thank you.
I cut it in half. Good luck, sir. Please tell me your name.
Enzer Alexis.
21 CF 12213. You're here charged with trafficking in fentanyl, 28 grams or more, unlawful use of a two-way communication device, and carrying a concealed firearm. I'm going to appoint an attorney to represent you. There's probable cause. Does the state wish to be heard on bond?
No, Your Honor.
What level felony is 28 grams or more?
I believe it's first degree, but I will double check that.
We cannot figure out why it keeps doing that.
Trafficking in fentanyl is an F1, Your Honor.
All All right, I'm going to set your bond at $150,000 on count one, $150,000 on two and three. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand? You can't possess a weapon, firearm, or ammunition. All right, good luck. Please tell me your name.
Good afternoon, Osvaldo Pencosme.
Sir, you're here because a warrant was issued for your arrest in 20 CF 14242, charging you with grand theft and dealing in stolen property. Another judge has already found probable cause. I'll appoint an attorney to represent you. Your bond is $2,500 on count one, $1,000 on count two. You're not allowed to return to the scene or have contact with any victim, witness, or co-defendant in the case. Do you understand?
Yes, ma'am.
All right, good luck.
Thank you.
Your Honor, do you see that he had another warrant?
Nope, hold on a minute.
(2017 CF).
Yeah, it's really confusing because that's in the middle of the dealing in stolen property, so that's why I missed it. This is really interesting. All right. Sorry, you have another warrant, 2017 CF 14595. It's actually capious. You failed to appear for arraignment on charges of possession of an anti-shoplifting device, 2 counts of that, petty theft of $100 or more, and petty theft. There's no bond authorized on that, and I'll appoint an attorney to represent you. Good luck. Please tell me your name. What's your name?
A.B. Moser Harold.
All right, this is a dozen cases.
This is a similar case to the one we discussed earlier with the issues and other cases.
Well, hold on, I gotta call all the cases.
Yes, Your Honor.
20 CF 10346, 20 CF 2294, 20 CF 986, 21 CF 8543, 19 CF 8932, 21 CF 11617, 21 CF 3760, 20 CF 9410, 1348, and 7536. Sir, you're here because you have a number of capiases that have been issued for your arrest. On the capiases, you have no bond. I'll appoint an attorney to represent you in each of those cases. In 21 CF 8543, that's a warrant charging you with grand theft. Another judge has already found probable cause, and there is a bond. Your bond is $1,500, and you're not allowed to return to the scene of the crime. In 21 CF 11617, another judge has already issued a warrant for your arrest and found probable cause. The bond on that is $500. It's a charge of grand theft. You're not allowed to return to the Home Depot located at 13121 South Orange Blossom Trail. Do you understand? Counsel, because these are all capiases, I am not able to change those bonds.
I understand, Your Honor, but as to his out-of-bond cases, we should take no action so that we can resolve those cases.
When was he found incompetent?
We're trying to find that out. One of the out-of-bond cases. I know I've seen Mr. Creole before. He has 5 different cases. Just allow me a moment, Your Honor.
Okay.
But I do know there is a good faith argument in our office that he's kicked back often in at least one of these cases. And if they are moving to adopt the findings in other cases, I'm sure that's pending if not already been granted. And again, he is being held here on the previous, so I still intend to get my bond cases so that he can go through that procedure. Seeing those judges that he ordered his appearance and work with his attorneys to find or adopt any findings in those cases as well.
What says this? Oh, sorry. What says the state?
Your Honor, if you give me a moment, I'd at least like to find one competency hearing or issue before I agree one way or another, Your Honor. Just one moment, Your Honor.
Y'all, you had 2 hours between court sessions.
You're fine, I have May I approach?
Sure.
I will be right there.
That one more time, 21. The last one, of course. It's a grand theft. So it may not have been heard yet, but All right, sir, at this time, I'm going to take no action on your out on bond cases. Stay in touch with your attorney, okay? Good luck, sir. Please tell me your name.
Michael Hillman.
In 21 CT 4435, a capias was issued for your arrest for failing to appear for arraignment on a charge of driving while license suspended.
Yes, ma'am.
The bond is $2,000, and I'll appoint an attorney to represent you. In 21 CF 232, a capias was issued for your arrest for failing to appear for a hearing on charges of possession of a firearm by a convicted felon, carrying a concealed weapon by a convicted felon, and improper exhibition of a dangerous weapon or firearm. The bonds authorized are $10,000, $5,000, and $500. Again, I'll appoint an attorney to represent you. Good luck, sir. Please tell me your name.
Nell Hugger.
A capias was issued for your arrest in 20 CF 15012 for failing to appear for court on charges of attempted burglary of an occupied conveyance. There's 2 counts of that. The bond authorized is $2,500 on count 1 and $1,000 on count 2. I'll appoint an attorney to represent you. Good luck, sir.
I had went to court and they had like a suspicious package in the mail, so I couldn't make it, but I was calling the court and they told me that the case was thrown out.
So it sounds like you think you have a defense, and you may have a great defense to this, but because it's a capias, I can't change it. So call your attorney right away and have your attorney file a motion in front of the trial judge. And I'll ask Mr. Brantz, because he's a representative from the public defender's office here today. Can you make a note about that? Because I hate for him to sit if he really has an easily provable defense to failing to appear.
And then the I don't know, you said it's 2 counts?
Yes, it's 2 counts of the same charge.
Yeah, I don't understand that, because it's supposed, I ain't never had 2 burglary charges. And then I was innocent on that charge, on both, on that anyways.
So I don't know. All I know is what's on the capias. So you're gonna have to talk to your attorney about it and get it back in front of the trial judge. Because it says on the capias you have 2 counts. So
How much is the bond?
it's $2,500 on count 1 and $1,000 on, or $1,500 on count 2.
So it'd be like $350?
Was it $1,500 or $1,000? It's $1,000. So it's $3,500 total is your bond.
Okay.
So get in touch with your attorney right away. Please tell me your name.
Gary Allen Mahan.
You have a violation of probation in 16-01526. There's no bond on that. I'll appoint an attorney to represent you. And a warrant was issued for your arrest in 21 CF 11492, charging you with burglary of a structure and grand theft greater than $750. Another judge has already found probable cause. Your bond is $3,500 on count 1, $500 on count 2. You are not allowed to return to 532 North Bluford Avenue or have contact with any victim or witness. And I'll appoint an attorney to represent you in this case as well. Good luck, sir. What about David Marrero? Is that your name, sir?
Yes, ma'am.
All right. A capias was issued for your arrest in 20 CT 4352 for failing to appear for a court date on a no motorcycle license. The bond authorized is $1,000, and I'll appoint an attorney to represent you. And then in 21 CF 7422, a warrant was issued for your arrest, and the state has filed an information. So the warrant was for aggravated battery, great bodily harm, false imprisonment, and conspiracy to commit battery. Let me see what the state charged. Battery with great bodily harm and false imprisonment. Hold on one second. Does either party wish to be heard on bond?
No, Your Honor.
Just a reasonable bond, Your Honor. As to the failure to appear, would you consider a bond reduction on that?
No, it's a capias. So I can't change it. It's a failure to appear capias, not a probable cause order. It's the one I can't change. All right, your bond on count 1 will be $15,000. I'm sorry, count 2 will be $15,000, count 1 will be $5,000. You can have no contact with the victim or the co-defendant in this case. Do you understand what no contact means?
Yes, ma'am.
You can't possess a weapon, firearm, or ammunition. You can't return to Clicks Billiards. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, sir. I'm sorry, what? Oh, count 3, they didn't file it, so it's an ROR. Sorry. Mr. Brands, I ROR'd him on count 3 because the state didn't file that.
I think I knew that, I just didn't say anything yet. Thank you, Your Honor.
Okay. Y'all know we're waiting on you guys, right? Thanks. Sir, please tell me your name.
Name is Jacques Moore.
21 CF 12197. You're here charged with petty theft with 2 prior convictions. There is probable cause. I'll appoint an attorney to represent you.
Your Honor, as to bond, I believe the arrest affidavit suggests it was toothpaste, so I would have you consider that in your bond.
It does say that. Your client has a rather lengthy criminal history, but he was stealing toothpaste, it looks like. That's the accusation. All right, I'm going to reduce your bond to $500. You're not allowed to return to CVS at 5300 South John Young Parkway, and you can't have contact with any victim or witness in this case. Do you understand?
Yes, ma'am.
Good luck, sir. Please tell me your name.
Reginald Donaway Polar.
21 CF 12214. You're here charged with trafficking in fentanyl 28 grams or more, and unlawful use of a two-way communication device. I'm going to appoint an attorney to represent you. There is probable cause. Is this the bond schedule recommendation for this amount? Because we saw the co-defendant earlier.
Yeah, I was confused by that too, because I guess it did defer to the initial appearance judge, but then in interest of equity, Your Honor, I would have you set bond in the same amount.
Yeah, but what I'm going to do is bring him back and set his at $1 million. If that's the recommended bond, then I'm going to do that.
In the bond, yes.
Does anyone know?
I'm looking, Your Honor. Oh, man.
No, it's not. Nothing's where it should be.
The most I'm seeing, Your Honor, is 400,000.
Recommended from the schedule is 400,000?
Although there was, no, actually, there was $1 million.
I was like, I don't remember 400.
There's $1 million for 28 grams to 30 grams of morphine, opium, oxycodone, hydrocodone, hydromorphone, or heroin. But it does not list fentanyl as one of those illegal drugs. So it could be $1 million to $1.5 million, Your Honor.
All right, then I'm going to stay the bond at $1 million on count 1, 150 on count 2 with special conditions. You can't possess or consume any controlled substance, have contact with the co-defendant in this case, or any other known drug dealers. You also can't possess a firearm or a weapon of any kind or any ammunition. Do you understand?
Yes, ma'am.
All right, good luck. And now we got to recall the co-defendant. Can you guys bring back Alexis Kenzer? That's fine. Sir, come on up and tell me your name. Okay. 21 CF 12183. I'll find his refusal of willing waiver of his appearance. I'll appoint the public defender's office. There is probable cause. I'll stay the bonds at 1,000 on counts 1 through 4 each, 500 on count 5. He's not allowed to possess or consume any controlled substance without a valid prescription, have contact with any known drug dealers. And at this time, I'm revoking his ROR in 21 CF 3957. What's your name, sir?
Good afternoon. My name is Louis Solar.
A capias was issued for your arrest in 21 CF 11620 for aggravated stalking after an injunction, violation of an injunction for protection against stalking or cyber stalking. 1, 2, 3, 4, 5, 6, 7 counts of that. That's a probable cause order. Can the state advise if this, is there an information filed in this case?
One moment, Your Honor.
Thank you. I'm going to appoint an attorney to represent you, sir.
He does otherwise qualify for pretrial release, Your Honor. We have limited criminal history as well.
He has 6 counts of violating an injunction against stalking and aggravated stalking after an injunction.
Yes, Your Honor.
Oh,
Otherwise qualified.
I'm just going to confirm, Your Honor. I believe I looked this one up, and everything that's listed is what he was charged with, but I will confirm that, Your Honor.
I need more information to set bond. That's why I'm asking. I don't have the affidavit. When it's a capias like this, that's literally all the court gets is a capias. It's super useful. I didn't call it. Oh, they're not here. I just skipped it because he was the one standing there. What happened with Roxanne Shavers? Okay, we'll have to address that in a minute.
Yes, Your Honor. Everything listed is what the information was filed on the information.
Okay, can you tell me what that is so that tell me what the facts are? Give me the.
On the information or the?
Yes, or if you have it, Do you have an arrest report or anything that?
Let me see if I have that. It's 43 pages, Your Honor.
43?
Yes, Your Honor. It starts back in January 25th of 2021. Violation of injunction. Victim is Angelica Maria Hernandez. While at her residence, she noticed a blue Nissan Sentra bearing Florida tag PKKU21. And she saw defendant exit the vehicle and walk to her neighbor's garage, which is just across the street from her residence. The injunction was already in place. The information. Count 1 is 20th December 2020 and 23rd of April 2021. Count 2. 25th of January 2021. Count 3. 27th of January 2021. Count 4. 10th of March 2021. Count 5. 4th of April 2021. Count 6. 20th of April 2021. Count 7. 22nd of April 2021. Count 8. 10th of March 2021 again. The last one is for cyber stalking. Against stalking, or it's the violation of the injunction, Your Honor.
All right, thank you. So, just a moment, sir. Mr. Brantz, after reviewing the probable cause affidavits, this court is struggling to come up with any reasonable bond conditions with which your client will comply. It appears that there's a pattern of him refusing to comply with court orders. So I'm asking if you have any suggestions for reasonable conditions of bond with which he'll comply.
Yes, Your Honor. There are a couple conditions that pretrial services can offer that aren't typically included in an injunction. They can order a curfew, or you can order a curfew, excuse me. You can require the defendant to relinquish all weapons. You can require the defendant to meet with the pretrial supervisor to keep a schedule of where they'll be and when, similar to community control. But as these are not punishable by life offenses and the state has not filed a pretrial protection motion, Mr. Solar is
So the court has to balance his right to bond with protection of the citizens of Orange County as well as the victim in this case. The allegations are, in the probable cause affidavit, repeated being within 500 feet, threatening with weapons, as in a gun pointed at the victim, the lasers on the victim. I mean, this is very egregious violations of an already existing court order. So.
I understand, Your Honor, and in that severity, I feel the state should file, if they wish to hold him no bond or pretrial, they do need to file a motion to
well, we can,
Pretrial detention motion.
we can talk all day about what we'd like the state to do. Has the state filed a motion for pretrial detention?
No, Your Honor.
Are you intending to?
I do not know
Then
at this time, Your Honor.
Then legally at this time, Your Honor, Mr. Soler is entitled to file on these charges, along with any conditions you provide, Sequel.
But that's what I'm asking. So he's already demonstrated that he's not going to comply. So,
And that was with the injunction in place. As I said, you can have pretrial services, do a curfew, do a check-in, additional things that aren't usually included in.
all right, Mr. Soler, you keep raising your hand. I want to make sure you understand. You can say anything you want, but everything you say is being recorded and can be used against you later. Do you understand that?
Hello, Your Honor. I just want you to take into
Hold
consideration.
on, I want to make, you didn't answer me. Do you understand that?
Yes, ma'am.
All right, if you want to speak to the court, I'm going to have you raise your right hand and be sworn in.
Ma'am.
Do you swear or affirm that testimony about to give should be the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead, sir.
Good afternoon. I just want you to take into consideration, I am a college student that's currently attending UCF. I really can't miss out on my college. So if you just want to take that into account, I'm currently pursuing my bachelor's for criminal justice.
All right, thank you, sir. At this time, I'm going to place you on pretrial release and require that you post a monetary bond. Your bond on count 1 will be $50,000. Counts 2 through 8 will be $1,000 each. You can have no contact with the victim. Do you understand what no contact means?
I understand.
Tell me what it means.
It means don't go within 500 feet of the victim, nor contact through social media, nor any contact whatsoever, ma'am.
You can't speak to her, you can't text her, you can't send a message through friends or family. You are correct, you can't contact her on social media. I am also going to order that you can't be within 1,000 feet of her residence or place of employment, not 500. Do you understand?
I understand.
You can't possess a weapon, firearm, or ammunition. I'm ordering that you must surrender all firearms to law enforcement within 24 hours of your arrest.
Your Honor, I have no weapons. I mean, you can search my house.
All right, well, if you have nothing to surrender, you don't have to, but
Understood.
there's an allegation of a firearm in one of these cases, so. You can't have contact with any of the other witnesses in this case. Does she also go to UCF?
No, I'm not sure really who the injunction is against, Your Honor. I just know where they live.
Do you have the victim's name and the information?
I just closed that down, so one moment, Your Honor.
I can't hear you.
I just closed that down, so one moment, Your Honor. Her name is Angelica Maria Hernandez.
You understand that's the person you can have no contact with?
I understand. I'm sorry. I understand.
All right, good luck, sir.
Thank you. Have a good one.
You as well. Roxanne Shavers refused. That's 21 CF 2939. It's a capias. I'll find her refusal a willing waiver of her appearance. Her bond is $2,000. I'll appoint your office, Mr. Brantz. Ma'am, please tell me your name.
Ira Stanberry.
In 19 CF 17359, A capias was issued for your arrest for failing to appear on charges of battery and false imprisonment. There's no bond authorized on that capias, and I'll appoint an attorney to represent you. Good luck, ma'am.
Thank you.
Did we get Alexis Kenzer back, or Kenzer Alexis? Okay. Good afternoon, sir. I'm sorry, we had to bring you back. Is your name Kenzer Alexis?
Yes, ma'am.
All right, this is 21 CF 12213. After we saw you, we saw the co-defendant in this case and got some additional information. At this time, I'm changing your bond. It'll be $1 million on count one, and I'll stay the other two at 150 with all the same conditions. Do you understand?
Yes, ma'am.
All right, good luck, sir. Is the state ready for 33-day motions?
Yes, Your Honor.
Who do you have first?
So this still the same?
Edward Starcher, 21 CF 9286. Granted, notice of non-filing. Melanie Richardson, 21 CF 7447. Granted, notice of non-filing. Brian Jean-Marie, 21 CF 9259. Granted, no info. Kevin Thornton, 21 CF 9137. Granted, notice of non-filing. Patrick Clark, 21 CF 8808. Granted, notice of non-filing. Anthony Colliver, 21 CF 9261. Granted, notice of non-filing. William Strickland, 21 CF 9269. Denied, information was filed. Osvaldo Maldonado, 21 CF 9292. Granted, notice of non-filing. Daquan Woods, 20